Hello viewers, welcome to Courts Today by LiveLaw. Let us get to today's top headlines. The Allahabad High Court has granted further 6 weeks to Uttar Pradesh government for decision on relocation or rehabilitation of the Hathras Rape victims' family. The Karnataka High Court has dismissed a plea of Jayalalitha's legal heirs seeking return of her properties confiscated in the disproportionate assets case. The Telangana High Court has held that customer feedback on social media platforms like X is an acceptable mode of registering complaints against service providers. While affirming acquittal in a rape case, the Supreme Court said that the Prosecutrix's testimony did not inspire confidence. The Supreme Court has explained the principles to evaluate circumstantial evidence in criminal cases. The Apex Court has said that maintenance proceedings under Section 125 of CrPC are civil proceedings, though breach may result in penal consequences. And the top court has dismissed a plea to transfer cyber complaints against alleged victim of fake stock market investment scheme. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before moving ahead, I would like to tell you here, LiveLaw Academy is offering a value-packed opportunity for the aspiring judges. The Judicial Service Examinations Preparation course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study material. And all of this at a very affordable fee. If you are gearing up for the judiciary exams, this is a must-check opportunity for you. Find all details at www.livelawacademy.com and enroll today. The Allahabad High Court has granted an additional 6 weeks to the Uttar Pradesh government to decide on the relocation and rehabilitation of the family members of the Hathras gang rape and murder victim. The court was informed that the victim's family had submitted an application to the state government on 2nd December 2024, requesting relocation to Ghaziabad or Gautam Budh Nagar. While the state government had been given a deadline of 8th January 2025 to make a decision, the State Council requested an extension, citing administrative constraints, including the transfer of the additional Chief Secretary and the ongoing Kumbh Mela. Advocate Mahmood Prachar, representing the victim's family, objected to the delay and urged the court to direct the government to provide housing in the specified areas. However, the court decided to give the state 6 additional weeks to consider the request. The matter is now scheduled for hearing on 24th February. This case, as you must be aware, relates to the 2020 suo motu proceeding initiated by the court over the tragic incident of the rape and cremation of a 19-year-old Dalit woman from Hathras. The court had previously directed the government to consider relocating the family for their social and economic rehabilitation, as well as to ensure the children's education. The Karnataka High Court today dismissed an appeal by the legal heirs of former Tamil Nadu Chief Minister Jayalalithaa, seeking release of her assets seized in the year 2004 in a disproportionate assets case. Justice V. Srishananda rejected the appeal, which challenged a trial court's order denying the release of Jayalalithaas Property. The appeal was based on the claim that since Jayalalithaa was acquitted by the High Court and the case was abated after her death, the seized assets should be returned. But the Karnataka High Court upheld the trial court's decision. It emphasized that the Supreme Court had already issued a clear directive affirming the confiscation of these assets, and this directive was binding on all parties, including the legal heirs of Jayalalithaa. The High Court clarified that confiscation order was final and could not be contested through reinterpretation at the appellate level. The court distinguished between the nature of asset attachment during an ongoing trial and post-trial confiscation, stressing that while attachment is a temporary measure, confiscation is a conclusive action following a conviction. It highlighted that the appellants failed to present sufficient evidence to prove which assets were acquired before the designated check period. As a result, the court could not grant their request to exclude certain assets from the confiscation order under Section 452 of the CrPC. However, it has left open the possibility for the appellants to present proof in the future to establish which assets were earned before the check period. Moving ahead, the Telangana High Court has ruled that complaints made on social media should not be dismissed as insignificant compared to formal written complaints. The court emphasized that social media complaints or customer feedback are a legitimate and widely accepted way of registering grievances. It rejected the notion of ignoring such complaints, stating that adopting an ostrich stance, ignoring or downplaying them, is not appropriate. In this case, Justice Moushami Bhattacharya was dealing with a writ petition filed by a railway vendor whose license to operate a tea stall at Secunderabad railway station was allegedly cancelled with immediate effect without issuing notice or following due procedure after acting on a complaint against the petitioner on social media, specifically on X. His counsel referred to the special conditions of contract and contended that the vendor or the license holder should be given counseling in regards to any shortcomings or deficiency, which was not done here. That a notice of temporary closure should have been served on the petitioner, which too was not done. Lastly, it was argued that all complaints were made on social media platform X. The standing counsel appearing for Railways, on the other hand, contended that multiple warnings were issued to the petitioner and complaints that were lodged against him were serious in nature. Apart from charging more than the prescribed rate for refreshments and serving poor quality of food, the petitioner had also got into an altercation at the railway station which culminated in a serious confrontation. After perusing the documents filed in the court, it came to a conclusion that the allegations against the petitioner were grave in nature and multiple warnings were issued to him. In regards to the social media complaints, the bench found that they were serious in nature and health could not be looked over. Moving ahead, the Supreme Court has observed that in rape cases, if a conviction is based on the sole evidence of a single witness, even that of the victim herself, such evidence should inspire confidence in the court. The bench of Justices Sudhanshu Dholia and Prashant Kumar Mishra agreed that while the victim's statement is given very high value, the court must carefully examine the same. In this case, the prosecution claimed that when the victim, who was a minor, was returning from school, the accused grabbed her hand and threatened her with a knife. He then took her to a nearby grocery shop and sexually assaulted her. The accused was charged under IPC and the POCSO Act. However, the trial court concluded that the prosecution had failed to prove its case beyond all reasonable doubt and acquitted the accused. The same was affirmed by the High Court also. Therefore, the present appeal was filed in the Supreme Court. The Supreme Court noted that the medical report found no injuries on the victim. Additionally, the court pointed out contradictions in the statement of the victim, such as her claim of hitting the accused despite no injuries being found on him when he surrendered. The court also did not find it believable that the victim went with the accused without raising any alarm. Based on these circumstances, the court concluded that her statement did not inspire confidence. So the court refused to interfere with the impugned orders and dismissed the appeal. In a significant judgment, the Supreme Court has outlined key principles for evaluating evidence in cases based on circumstantial evidence. Dismissing an appeal in a rape murder case, a bench comprising Justices B.R. Gavai, K.V. Vishwanathan and Sandeep Mehta emphasized meticulous examination of both prosecution and defense witness testimonies, ensuring no material aspect is overlooked. It said that circumstantial evidence requires drawing inferences to connect facts. Each link must form an unbroken chain pointing solely to the accused's guilt, excluding any other hypothesis. The case here involved the 2012 rape and murder of a 9-year-old girl in Kerala. The accused was sentenced to death by the trial court and confirmed by the High Court. The accused passed away in January 2024 and his legal heirs continued to pursue the case with the attempt to clear his name. The Supreme Court highlighted a solid chain of circumstances. That is, the victim was last seen with the daughter of the accused and searches led to discovering the victim's body in the accused's house. Forensic evidence including DNA matching and bloodstains confirmed his involvement. The judgment stressed that findings of guilt must result from careful evaluation, ensuring they align with no other reasonable explanation. Though the appeal was dismissed, the death sentence became irrelevant due to the death of the convict. In another update, the Supreme Court has clarified that maintenance proceedings under Section 125 of CrPC are civil in nature, even though non-payment can lead to penal consequences. A bench of CJI Sanjeev Khanna and Justice Sanjay Kumar stated that these proceedings, while listed in the Criminal Procedure Code, should not be considered criminal cases. The court made this observation while ruling that a wife can still claim maintenance under Section 125 CrPC even if she refuses to comply with the restitution of conjugal rights decree, provided she has a valid reason. Referring to the 1969 Law Commission report, the court highlighted that maintenance provisions are included in criminal law for quick and effective enforcement, as criminal courts can handle these matters faster than civil courts. It reiterated a 1963 judgment that described maintenance proceedings as civil in nature, designed to offer a summary remedy for those in need. And lastly, the Supreme Court has dismissed a writ petition seeking consolidation of multiple cyber complaints filed against a petitioner who claimed to be a victim of cyber fraud. The petitioner here alleged that 3 complaints, all stemming from the same incident, were filed against him and violated his fundamental rights under Article 21 of the Constitution, including his right to life, personal liberty, and a fair investigation. The petitioner, a resident of Panipat, Haryana, claimed that he was defrauded through a fake stock market investment scheme operated via a WhatsApp group. He stated that after investing 6,65,000 in the scheme, he received unusually high returns within 2 days, which raised his suspicions. Upon seeking a refund, he got his money back through 3 transactions. But soon after, cyber complaints were filed against him in Andhra Pradesh, Tamil Nadu, and Gujarat. His counsel argued that the complaints were part of an extortion attempt by the cyber criminals and requested that all the cases be transferred to one authority in Haryana for a consolidated investigation. But a bench comprising Justices Bela Trivedi and P.B. Varale declined to entertain the petition, stating that it could not be entertained under Article 32 of the Constitution. For more information on the cases that I mentioned, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share, and subscribe to our channel.